You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 48, the All Elements Test Response to Obviousness. My name is Dr. Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com, that's D-I-A-M-E-N-T, patentlaw.com, or if it's too hard to remember, you can get to it through patentingforinventors.com, that's patenting, F-O-R, inventors.com, or call me at 424-281-0162. And while most attorneys can only practice in states where they're members of that state's bar, patent attorneys are actually allowed to practice patent law in any state, so feel free to contact me regardless of where you live. In the last episode, I went through a very broad overview of what you're likely to see in an obviousness rejection. The examiner is likely going to find something similar to your invention that has almost everything that you're saying your invention is. Then the examiner is going to find something else that has that missing piece. And then the examiner is going to say it's obvious because a person having ordinary skill in the art would combine those things to make your invention. Now, almost always, the examiner is going to find basically 2 or more patents or patent applications to make an obviousness rejection. Occasionally, the examiner is going to find just one reference and make an obviousness rejection. For example, if you're trying to claim a pink polka dot pencil that's exactly 6.372 inches. The examiner doesn't need to find something that actually has pink polka dots or find some other writing instrument that is 6.372 inches in order to combine them with a pencil to arrive at your invention. The examiner can just find a pencil and say that putting pink polka dots on it is just a design choice, and changing the dimensions to 6.372 inches exactly is also just a design choice and not something patentable. Now, if there was some really special reason about what your pencil could do because it was exactly 6.372 inches and pencil slightly longer or shorter couldn't do what your pencil does, then maybe you have an argument. But for the most part, just changing dimensions or ornamentation isn't going to make your invention patentable. The examiner is going to find generally 2 or more references and combine them together. Let's go back to the mechanical pencils because they have some simple parts to them. Let's say you're claiming a particular kind of mechanical pencil where the clicking button is on top, and there's an eraser that covers a hole at the top, and the eraser can be removed so the person can drop in some more pencil lead. And let's say that you were also the first person to do all this, and all other mechanical pencils before had a side clicking button, and the only way to get pencil lead inside the pencil was to stick it through the small little hole where pencil lead comes out. Now, what you did by having the hole on top where you can remove the eraser, that would have been a good improvement because you don't need the fine dexterity if the top has a large hole that you could just drop some pencil lead into. So we're going to do something similar to what I did last episode. In your claims, you say that your pencil has a long cylindrical body, a tip with a hole for lead to come out, a button at one end that has a hole going through the button, and a removable eraser positioned on top of the button. And let's say what exists already is a mechanical pencil with a long cylindrical body, a tip with a hole for lead to come out, a button on the side, and an eraser positioned at the end of the pencil. Now we can see this mechanical pencil has some, but not all of the features that you say your invention is. The examiner will cite to this and other mechanical pencils and look for some other pencils that have the other features that we're missing. So the examiner finds a pen that has a clickable button on the top of the pen. Now, you might get a rejection where the examiner combines the mechanical pencil with most of the features with a pen that has a clickable button on top and says that your invention is obvious. So what's wrong with the examiner's rejection? The problem is that even if you combined all the features of the mechanical pencil that he found with all the features of the pen with the button on top, it still doesn't have all the features of your invention. It doesn't have the button with the hole through it so that pencil lead can be dropped in. So that prior art lacks all of the elements. Now, put in a more mathematical way, if you're trying to claim a pencil that has parts A, B, C, and D, and the examiner finds one pencil that has parts A and B, and another pencil that has part C, and rejects based on obviousness, your response is that nowhere in the prior art is part D disclosed. So even if a person having ordinary skill in the art combined all the prior art, all of the limitations in your invention are not disclosed in the prior art, so your invention can't be obvious. Okay, so how do you actually respond? There's a section in the Manual of Patenting Examining Procedure called the MPEP that you want to cite to, and it's section 2143.03, and it's titled, All Claim Limitations Must Be Considered. It says that, quote, an examiner must consider all claim limitations when determining patentability of an invention. Now, it goes through in more detail and gives examples and cases where this section is based off of, but basically it's saying that the examiner can't just ignore one of the limitations in your claim. Limitations, as I mentioned in previous episodes, can be thought of the different parts of what you're saying your invention is. The examiner has to consider all of these. This is called the all limitations test or all elements test. People interchange the words limitations and elements a lot, but legally limitations are what are in your own claims, and elements are the things that match up to your limitations that are in the prior art. But both generally just refer to the parts of what make up the invention or the product. So you might write something like, in the office action, the examiner rejected the claims under patent 1 in view of patent 2, and you write in the inventor's names and the patent numbers of these two patents that the examiner cited, and then you say, in the present invention, Claim 1 requires a button with a hole covered by a removable eraser. Neither Patent 1 nor Patent 2 disclose the elements of the claimed invention. Section 2143.03 requires that all limitations must be considered. The examiner failed to consider the limitation of the button with the hole and removable eraser, and the prior art does not disclose this limitation. Thus, no prima facie case for obviousness has been established. Applicant requests reconsideration of the claim and withdrawal of the rejection. A notice of allowance is respectfully requested. You'll probably want to flesh this out a little bit with a little bit more details about what your button is and how it's not shown in the other prior art. You might want to point out some figures that are in the prior art and really say how, this isn't shown anywhere in any of the figures or any of the text. But that's going to be the nuts and bolts of it. So what you want to do when you get an obviousness rejection is look through all the limitations of your claims and see whether it's even true that these limitations exist in the prior art, or if the examiner is just glossing over them. So what I went through just right now is somewhat of a basic kind of response that's easier to tackle than other kinds of obviousness rejections because it's a little more black and white. Did the examiner consider each and every one of the limitations in your claim? It's a yes or no answer. If the answer is no, then I've outlined how you should respond to that kind of rejection. It's more challenging when the answer is yes, that all of the pieces of your invention actually do exist separately, but you want to get a patent because your combination of all those pieces has never been done before, and when they're all put together, you're saying that it's not obvious to combine them and that you deserve a patent for this non-obvious combination. Now, I'll go over how to respond to that scenario in the next episode. If you want help with your patent applications, you can contact me through my website at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.